We got some breaking news. In a 2-1 decision, an appeals court has ruled against the Trump administration and against Donald Trump's continued use of the Alien Enemies Act of 1798 to deport Venezuelan undocumented people to El Salvador without due process. 2-1 decision led by Judge Henderson, appointed by Bush, Judge Millett, appointed by Obama. In dissent, as I predicted, Judge Walker, appointed by you-know-who, Donald Trump. Let me break it down for you. This is about the temporary restraining order that the chief judge of the district court, Jeb Boasberg, entered last week against the continued use of the Alien Enemies Act to deport undocumented and have them land in El Salvador, a prison so bad, the Supermax prison, so bad that over 350 people have died of quote-unquote natural causes in the last year and a half alone. That's if you included natural causes being beat to death. And that's what concerns all of the judges about the irreparable harm to be suffered by the Venezuelans. This is about due process. As Judge Millett put in her concurrence, this is about the intersection of the Alien Enemies Act and due process under the Fifth Amendment of the Constitution. That's the intersection that we're talking about. And two of the judges, for different reasons, kind of backed into the same place, that Jeb Boasberg's temporary restraining order would not be disturbed for the next 2 weeks or 3 weeks while they get to the merits of what Judge Millett called an unprecedented set of circumstances, the attempted exercise by a president of war powers when there's been no proper declaration of war. All of the judges in the majority said the same thing. Judges are empowered to interpret whether the Alien Enemies Act is being properly exercised or not, to interpret the words of it, to interpret and apply the Constitution to the words. If it deals with constitutional challenges or matters of interpretation, that is when a federal court must exert its jurisdiction. Now, Judge Henderson, who wrote a concurrence, again, they all got to the same place, at least two of the judges. She said that there is likely jurisdiction of the appellate court, even though this is a temporary restraining order, because she thinks that the government arguing that this deals with the interference of foreign policy, its negotiations of the contract, the pay to play to put these people for $6 million in an empty El Salvadorian prison to satisfy its dictator, President Bukele, that tipped it over into being like a final order to be reviewed by an appellate court. Judge Millett, she's the one that during oral argument said, "Are you kidding me? The people suspected of being Nazis during World War II in America were given more due process rights than the people that you're sending off in the middle of the night in shackles to have their heads shaved and thrown into a dark, dank prison." So dark and dank that Judge Boasberg in his own recent order said there is reporting that after they beat prisoners to death, they put the rotting carcasses of these dead individuals in prison cells in order to freak out the living prisoners. That's where we just deported people. And all of the judges, except for the Trumper, threw up their hands and said, why? Why? What's the rush? Why can't we get to the bottom of the appeal? Why do we have to disturb the temporary restraining order? Why do you have to deport pursuant to the Alien Enemies Act, the only time in our history where it's been exercised during peacetime? And they said both Millett and Henderson both came to the same conclusion. When you look at the words, there must be a war declaration by Congress, which has not existed, or an enemy incursion or an invasion that's ongoing before our very eyes. And that's up for the courts to determine whether the president has made the right call on whether there is an invasion or an incursion. And they cite to a case it's really the only case that's been cited over and over again, a United States Supreme Court case from the 1950s called Ludecky. In Ludecky, the issue was whether the war was still going on so that Germans and others could be deported under it. Because if the war was over, the war power was over, and the use of the Alien Enemies Act is over. Because even though it's a powerful tool in the president's toolbox, he only gets it during wartime. He gets disarmed after that. And the courts, the Supreme Court ruled that a federal judge was the right place, one judge in one district was the right place to make the interpretation of whether there was a war and the definitional drivers of the Alien Enemies Act. Let me read to you from a couple of interesting points in both the concurrence for Henderson and the concurrence for Millett. And to answer the question I know that's come up, two concurrences do equal a majority. Even though they might have done it for different reasons, if they vote to deny the Trump administration's attempt to block or enjoin the temporary restraining order, then it doesn't matter that they're doing it on different grounds. But let me read to you from, they all do the historical analysis of how we got to the Alien Enemies Act. It had some sisters and brothers that fell by the wayside because they were likely unconstitutional. This is the only one remaining, and the real driver for it is the existence of a war. And so so Judge Henderson, she says on page 2 of the order, the Alien Enemies Act contains two provisions, a conditional clause and an operative clause. The conditional clause limits the act's substantive authority to conflicts between the United States and a foreign power, not the Tren de la Agua, narco gang. Specifically, there must be a declared war between the United States and any foreign nation or government, or an invasion or predatory incursion perpetrated, attempted, or threatened against the territory of the U.S. by any foreign nation or government, and then a presidential proclamation of that event. If these conditions are met, then the president gets the powers. As she says on page 3, thus the act vests in the president near blanket authority to detain and deport any non-citizen whose affiliation traces to the belligerent state. What's the belligerent state? Their argument that Venezuela has been infiltrated by a narco gang living in the United States? A central limit to this power, Judge Henderson continues, is the act's conditional clause that the United States be at war or under invasion or predatory incursion. She then goes on page 12 of her concurrence, I'll get to Millett in a minute, to discuss the Ludecky case. The Ludecky versus Watkins case, there she said on page 12, the Supreme Court reviewed the habeas petition of a German alien detained under the act during the Second World War. Following Germany's unconditional surrender and cessation of actual hostilities, the petitioner claimed that there was no longer a war, so the president lost the power under the Alien Enemies Act. From Ludecky, the judge says, and when the shooting stops, in other words, when the shooting stops, so does the president's power under the act. And so there was a question about whether this was a political question or this is something that judges can determine. From Ludecky, Judge Henderson says, the government, Trump's side, draws the mistaken inference that all questions of authority under the Alien Enemies Act are political and thus beyond the scope of judicial review. But she goes on to say the questions of interpretation and constitutionality, same thing Millett says in her concurrence, the heartland of the judicial ken, this is what we get paid to do, are subject to judicial review. So I don't want to hear your argument, Trumpers, Trump side, that we don't have the power and what you do is completely unreviewable because you're cloaked with the superpowers of the Alien Enemy Act. And then listen to this on page 26. After she goes through all the different interpretations, she talks about how bad things are in El Salvador. We're not even sending them to Venezuela. We're sending them to a foreign country, okay, outside of this foreign country for them, to a worse one. Talk about out of the frying pan and into the fire. This is what Judge Henderson says, and she's the Bush appointee. The executive's burdens are comparatively modest. Lifting the injunction risks exiling plaintiffs to a land that is not their country of origin. Indeed, at oral argument before this court, the government in no uncertain terms conveyed that, were the injunction lifted, it would immediately begin deporting plaintiffs without notice. Plaintiffs allege that the government has renditioned innocent foreign nationals in its pursuit against TDA. That's the narco-terrorist gang. For example, one plaintiff alleges that he suffered brutal torture with electric shocks and suffocation for demonstrating against the Venezuelan regime. In other words, he's a political exile in America. While awaiting adjudication of his asylum claims, he was expelled to El Salvador because of a misinterpretation about a soccer tattoo. I think he had a Real Madrid soccer tattoo. I mean, if I wasn't a baby, I'd get a Real Madrid soccer tattoo. The government concedes it lacks a complete profile. There is a public interest in preventing aliens from being wrongfully removed, particularly to countries where they are likely to face substantial harm. Now, Judge Millett got popular very quickly because in her oral argument, she made the Nazi reference. Here's what Millett has to say in hers. She said this case arises on page 2 of her concurrence out of the intersection of the Due Process Clause of the Constitution. Amendment 5, the Due Process Clause, the Fifth Amendment, and the Alien Enemies Act of 1778. She said at its most, on page 3 of her decision, or her concurrence, at its most basic, due process requires notice of adverse governmental action, an opportunity to be heard, and the right to an unbiased decision maker. Why is that missing here, she's questioning. Page 5, she says, if there's been no formal declaration of war by Congress, the president must make a public proclamation and allow enemy aliens a reasonable time to comply with the proclamation's orders. We know none of that happened here. She then goes on, and this is my favorite part of both orders, to call the Trump administration basically inconsistent liars. She says, even on page 22 of her concurrence, even more to the point, the government's persistent theme for the last 10 days has been that the district court's oral direction regarding the planes was not a TRO with which it had to comply. Oral statements are not injunctions. Oral statements are not injunctions, which is a lie, by the way. She says, I leave the merits of that argument for the district court, for Judge Boasberg. But the one thing that is not tolerable is for the government to seek from this court a stay of an order that the government at the very same time is telling the district court it is not an order with which compliance was even required. Heads, the government wins. Tails, the district court loses, is no way to obtain the exceptional relief of a temporary restraining order stay. She doesn't even think the appellate court has jurisdiction. Now, Walker, a Trumper, he just said, I think this is a habeas corpus petition that should have been brought in Texas. Thank you for that. We knew that was going to come from the way he asked questions during the hot bench oral argument. What's the takeaway now on this? As I end this hot take, blocked for now the attempts by the Trump administration to get out from under the temporary restraining order of Boasberg. They cannot use, as of this moment, the Alien Enemies Act to continue to deport people. Doesn't mean they're forced to release them into the general population of society, or even stop using the Alien Enemies Act to arrest people or to detain people. It just means you can't deport them to El Salvador for now, until it plays out at the district court level on the briefing about temporary restraining order to preliminary injunction and the rest. Once it gets to preliminary injunction, any moment now, then it can get to the United States Supreme Court for a final determination. Although I expect the Trump administration to try to skip that step, appeal through John Roberts, the Chief Justice, and try to obtain a reversal right now and get out from under the Boasberg temporary restraining order. They get out from under that, they won't be found in contempt, and you see where that's going. I just don't think they win at the Supreme Court level. I'll continue to follow that story here on the MeidasTouch Network. Come on over to Legal AF, the YouTube channel. Hit the subscribe button there. This is a minute-by-minute story at the intersection of due process and the Alien Enemies Act, as Judge Millett put it, and we'll follow it the only place I know of on the YouTube dial. Legal AF and the MeidasTouch Network. Till my next reporting, I'm Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.